Hello everybody, my name is Paul Taylor. I'm an attorney with Truckers Justice Center, and I want to thank Desiree and Real Women in Trucking for allowing me to present today. I was in fact offered the opportunity to come along on your cruise. Unfortunately, I can't be there. I would love to. However, business and other travel that I had got in the way here. But I thank you for being here. I have sent some written material if you want to follow along with respect to my presentation. I'm going to do two presentations to you. One is going to be on the Surface Transportation Assistance Act, and the other one is going to be about carrier-sponsored lease purchases. So as a matter of background, I'll just tell you a little bit about our firm. I have been a practicing attorney for almost 34 years, all in trucking, all representing drivers all of those years, but in the first 10 years of my career, I represented trucking companies as well as drivers. For about the last 22 to 24 years, I have primarily represented drivers. I retain a few trucking company clients, but right now I represent no trucking companies, and the only broker I represent is my brother's company. I grew up in the trucking business. I've been a dispatcher, I've been a safety supervisor. I worked with several of my brothers and my father for a number of years, went to law school at night. I left the family business and went to work for a trucking company in Red Wing, Minnesota, now known as Lawrence Transportation Services, and I wrapped up my law school days at night, working during the day for the trucking company and going to law school at night. I am a 1984 graduate of William Mitchell College of Law, now known as Mitchell Hamlin. It is the law school where former Chief Justice of the Supreme Court Warren E. Burger attended. I have handled cases at all levels of the federal court system, including a trucking case, several trucking cases that went all the way to the United States Supreme Court, although I haven't been before the United States Supreme Court in 22 years. So we're going to talk in this first talk about the Surface Transportation Assistance Act. That is a whistleblower act. It's summarized on the first page of your materials. And essentially what the Surface Transportation Assistance Act does is protect you at work from retaliation, including firing or suspension, discharge, or blacklisting, if you have done something to foster commercial vehicle safety. So what the law protects is, number one, is complaints. A complaint related to a violation of a commercial vehicle safety regulation. And the courts and the Department of Labor, these cases go through the Department of Labor primarily. They have construed that filing a complaint is protected from retaliation if, one, the complaint is objectively reasonable and subjectively reasonable. In other words, you've got to reasonably believe there's a violation, and two, an objective truck driver, somebody similarly situated to you, with similar experience, expertise, type of work you do, would believe that there is an actual or a potential violation. So the law protects complaints related to violations of commercial vehicle safety regulations, and that includes complaints made to a supervisor, and it doesn't have to be your supervisor, it has to be a supervisor, and complaints made to the government. For example, if your trucking company that you're working for does not correct a defect with the trailer, say you have 3 bald tires and bad brakes and 4 marker lights out on the trailer, and they won't repair it, and you go and report yourself to DOT. You tell the company, I'm going to put that truck into a scale because you're not repairing it, I'm calling the DOT on you. That's protected. Not only the complaint to the employer, the fact that you're telling them about this violation, telling them that you're going to go to the DOT, but the fact that you went to the DOT. So the first category of protected activities is complaints to the government or to the employer about reasonably perceived violations of commercial vehicle safety regulations. For that complaint to be protected doesn't mean you have to prove an actual violation would have occurred, but that you had an objective, good faith belief that one occurred. The next category of protections under the Surface Transportation Assistance Act is testimony. So if you testify in a union grievance proceeding, and I don't think any of you are out there are union employees, but if you testified before Congress, or you're a witness, for example, in somebody else's case, or you provide a statement, that's testimony. If somebody else got fired because they wouldn't break, let's say, hours of service, they wouldn't log time waiting as off duty, if you're at a Walmart distribution center, and you support that person with a statement saying, yes, the XYZ trucking company did that to me too and asked me to log off duty when I was actually on duty, not driving, waiting to get unloaded at a Walmart distribution center, that is testimony. The next category of protected activity, and when I say protected activity, I mean protection against retaliation. There are statutes like the National Labor Relations Act has protected activity, trying to form a union. The Title VII of the Civil Rights Act has protected activity, for example, complaining of sexual harassment, racial discrimination. So in the STAA, we got complaints, we got testimony, and the third category is certain refusals to drive are protected under the STAA. Retaliation is prohibited or discharged because you do a protected work refusal. Now, that has to be predominantly a refusal to drive a commercial motor vehicle. The term is operate, a refusal to operate. The statute makes it unlawful for a employer or any other person, so it could be the dispatcher, to retaliate against an employee because the employee refuses to operate a commercial vehicle because the operation would result in an actual violation of a commercial vehicle safety regulation. So essentially under that provision, you are required to prove that the statute would have been, an FMCSR would have been violated but for your refusal to drive. So what does that mean? For example, we know that the DOT Commercial Vehicle Safety Regulations in Part 393 prohibit operation of a commercial vehicle with any of the required lamps not working. Doesn't say it has to be an out-of-service violation. The statute prohibits retaliation because somebody has refused to violate any commercial vehicle safety regulation. So the 3 clustered marker lights on the back of a semi-trailer, if one's out and you refuse to drive, you are protected from retaliation. If the company says, well, you need to drive to, okay, we'll get it fixed, there's a truck stop 20 miles down the line, and you say, no, I'm going to wait here on the side of the shoulder until you have a road service call out there, that is protected. I'm not necessarily suggesting you do that, but no matter how minor the violation is, you are protected from retaliation for refusing to drive because driving would result in an actual violation of a commercial vehicle safety regulation. Let me give you another example. Part 396, I believe it's 396.3, is the regulation that says no vehicle shall be driven unless it's free of leaks, oil leaks, and properly greased. Now, I don't know about you, but I find it very difficult to believe that there's any truck out there that doesn't have at least some leaks. But in fact, a literal reading of the rules says that the truck shall be properly greased and free of oil leaks. So these are the types of things that could come under refusal. Could be refusal to drive due to hazardous weather, all sorts of things. Now, I'll get into more detail later. I'm just trying to give you an overview of the statute's protections. Another category of protections covered under the STAA are refusals to drive because you have a reasonable apprehension of serious injury because of the vehicle's unsafe condition. In other words, this is sort of like the complaint section, where you don't have to prove an actual violation, you just have to prove that you had an objectively reasonable belief of serious injury because of a vehicle's unsafe condition. Now, you could have a refusal to drive because of one marker light out that's protected under the section which I just talked about before, where the driving would actually violate the regulation, and it may not be protected under another section. Conversely, You could have, say for an example, a refusal to drive due to hazardous weather, where you might have an objectively reasonable belief based upon watching weather reports on the internet or the Weather Channel, looking outside your window, seeing snow falling, cars slipping, but you may in fact, you may not be able to prove that an actual violation of the bad weather rule, 392.14, I believe, would have occurred, but you might have had a reasonable apprehension of serious injury because of the vehicle's unsafe condition. And this statute has been interpreted that to include, doesn't necessarily mean that the vehicle's unsafe condition has to be caused by something wrong with the vehicle, but it can be due to fatigue, it can be due to bad weather and other causes. So we have in this category, these categories here: first, complaints; second, testimony; third, refusals to drive or refusals to operate because of a vehicle's unsafe condition. Final category of protected activity is accurate recording of on-duty hours. Excuse me. The statute does not specifically state that you are protected because you refuse, if you refuse to falsify a record of duty status. What it says is you may not be retaliated against, or retaliation is prohibited against a driver because that driver accurately records on-duty time. And that would mean driving time and on-duty not driving time. Now, in this era of e-logs, the accurate recording provision was brought in August of 2007, signed into law by President Bush, which strengthens certain protections and added protections to the STAA. So, in this day of e-logs now, which really weren't much on the horizon 11 years ago, I think Werner and UPS and Domino's Pizza had e-logs, but probably nobody else or very few people. So if you insist, I'd say, for example, and we had this issue today with a carrier, case we're working on today in my office, where the driver was instructed to simply drive at a slow rate of speed, 10 miles per hour or less, and it wouldn't show up on his e-log because the company wanted him to drive about 2 miles outside of a truck stop to swap in the middle of his 10-hour break. So in essence, the company was asking him to continue to record that time as either sleep or berth or as off-duty. But in fact, he recorded it as driving time, and driving time is part of that whole universe of on-duty time. So we have the four lines. So I mean, if you're talking on-duty, not driving, driving is also on-duty time. So if you are accurately recording on-duty driving or on-duty not driving, like the 8 hours you wait at a Walmart distribution center to get unloaded and the company's asking you to go off-duty, you are protected from retaliation for accurately recording on-duty hours. So that's an overview of the statute, at least what it protects.